I will open a public hearing on Senate Bill 710A.
Chair Crop, members of the committee, Senate Bill 710A comes with you unanimously from the Senate floor with 29 ayes and 1 excuse. The measure authorizes the Chief Justice of the Oregon Supreme Court to establish minimum continuing education requirements for judges of the county circuit courts, tax court, court of appeals, and Supreme Court. It further provides that the continuing education requirements established by the measure must include evidence-based and trauma-informed education related to domestic violence, sexual assault, stalking, and other matters related to interpersonal violence. Finally, the measure directs the state court administrator to submit a report no later than September 15, 2027, to the interim committees of the Legislative Assembly related to the judiciary regarding compliance with the requirements established by the Chief Justice pursuant to the measure. The measure repeals the reporting requirement on January 2nd, 2028.
Senators, welcome.
Thank you. Chair Krupp, Vice Chairs Choatson and Wallen, and members of the committee. For the record, I'm Janine Salman. I'm the state senator for Senate District 15. And that includes areas of Forest Grove, Cornelius, Hillsborough, and the Rock Creek area of Western Washington County. I come to you today in support of Senate Bill 710A. As a senator and a board member of the Family Justice Center of Washington County, I have heard from numerous advocates and survivors that improvements to the family court system are critically needed. The stories are very traumatic to hear. In order to protect children and survivors of abuse and domestic violence, we must have better training and awareness for our judges all across Oregon. It can have dire consequences if they do not have trauma-informed training. The testimony heard in the Senate committee was very impactful from the 2 judges, including the presiding judge of Washington County. As a survivor of domestic violence myself, growing up in a home where domestic violence was a traumatic and constant pattern, I understand this pain and fear and critical safety for young children. I was very fearful of the outcomes during my parents' divorce proceedings back in the early 80s. I was not certain if visitation would be required, and it terrified me. Thankfully, my dad did not seek visitation rights or custody. In 2023, I brought forward a bill called Caden's Law. The sole focus was about keeping children safe from family violence. This was a bill based on a very tragic story in Pennsylvania that saw a young child, Caden, murdered by her abusive father during an unsupervised court visit, despite the court's knowledge of the father's history of violent and threatening behavior. A portion of Caden's Law would have mandated judicial education so that judges would receive initial and ongoing training on domestic violence and child abuse in order to help prevent further tragedies like Caden's from occurring. That bill did not move forward, and since then, I have been working with the advocates and survivors alongside the Family Justice Center of Washington County, Oregon Law Center, and the Oregon Judicial Department on a concept focused on the judicial training piece. The advocates all agree that judicial training is the important first step in addressing the trauma and safety for domestic violence and sexual assault survivors. But we have much more work to do that will follow. Reopening trauma is not easy for anyone. And in our search for positive change, we ask survivors to come back again and again and again to share their stories. I am humbled by this work and the people that I have had the opportunity to work alongside. Thank you to Rachel Schutz, the Executive Director from the Family Justice Center of Washington County, the Oregon Law Center, OJD, and the countless survivors that worked on this policy alongside our office to lead to this positive change. Colleagues, I urge your support of Senate Bill 710A. Thank you.
Thank you, Senator. Senator Weber.
Thank you. Chair Krupp, Vice Chairs Wallen and Choatson. For the record, my name is Suzanne Weber, and it is my honor to represent the people of District 16 in the Oregon Senate. Since coming to the legislature in 2021, I have continued to work for the betterment of children. It's been my key focus. It was my focus as a teacher for 30 years. It was one of my focuses in serving in local government, and it continues to be one of my primary focuses today. and that's why I support Senate Bill 710. There is no way that we can understand what a child who is in the center of a family dispute is going through. I had a boy once. I had to testify in court for him to decide where he was going to go with his mother or his father. He took to wearing a black cape and a white shirt, and he read every book he could on magic just to make it go away. It was his coping medicine. Often, children experience unimaginable trauma, domestic, mental, physical, and sexual abuse, and more. And they desperately need help and someone to at least try to understand what they're going through and how to help them. There is nothing more damaging to a child in a family who is experiencing this abuse than to have a judge who is, in theory, charged with their welfare, make decisions that are completely counter to that welfare, even when the judge is well-meaning and simply acting out of ignorance. Senate Bill 710 gives the Chief Justice authority and instructs her to establish materials for education-based and trauma-informed continuing education for judges. Colleagues, our judges are educated in the law. However, when one of those lawyers becomes a judge, it is often the case that they need expertise in more than just revised statutes and administrative rule. They need to make decisions for the protection of children who are counting on them to be their last chance for protection. Senate Bill 710 will arm judges with the information that they need to do just that. I encourage the committee to advance it as quickly as possible, and I want to thank you for allowing me to be here this afternoon.
Thank you, Senators. No, thank you for being here. Judge, are you with us online?
Indeed, I am.
Welcome back.
Thank you for having me again. Chair Krupp, Vice Chairs Choatson and Wallen, and members of the committee. My name is Rebecca Guptill, and I'm the presiding judge of Washington County Circuit Court. I'm here to support Senate Bill 710 in concept in my individual capacity and based on my experiences as a judge who has presided over dockets involving family law, criminal law, and other areas involving and impacted by both domestic and sexual violence. I also previously served on the board of the Family Justice Center of Washington County for 5 years. Prior to taking the bench, my practice included family law, criminal defense, and juvenile law. Domestic and sexual violence are all too common, and the trauma and cyclical trauma caused by both can be seen in all types of cases that come before the court. There's currently no mandated training specific to educating judges on how best to handle these matters. Occasionally, a training may occur on these issues or touch on these issues, but not all judges likely attend for a variety of reasons, often a lack of time. Currently, judges have the same continuing legal education or CLE requirements of all other practicing attorneys. Oftentimes, meeting those requirements requires spending time engaging in CLEs that are not at all specific to judges and what we do. Often, judges are teaching those CLEs and getting credit as a result of doing so. The CLE requirements do not include a requirement for domestic and sexual violence education, and even if they did, it would be unlikely to provide skill-based education geared toward the needs of judges. It is my opinion that judges would benefit from their own judicial educational standards for continuing education rather than the current requirements that do not provide high-value specialized training for judges. The proposed mandatory training regarding domestic and sexual violence should be part of that judicial continuing educational requirement and should include evidence-based and trauma-informed education that provides specialized practical training for judges. Domestic and sexual violence and the trauma it causes impacts every type of case coming before the court, and not all judges have a legal background that has provided experience or education on recognizing or dealing with trauma. I'm lucky to have practiced in legal areas that provided me with exposure to and some education related to domestic and sexual violence, but still was not specific to judicial educational needs. This can become most obvious in the area of family law, where many cases directly involve domestic violence in a home. Currently, 86% of family law cases in Oregon have at least one self-represented party. It is common that a court might have a self-represented litigant who presents differently based on past trauma and the stress of the courtroom experience, particularly if that litigant is sitting in the same courtroom and up against someone who is abusive to them. Recognizing that dynamic and understanding it is crucial to being able to manage the courtroom and proceedings in those situations and to be able to make accurate credibility determinations, ensure that necessary information is obtained through the process, and to provide a more trauma-informed courtroom experience. This really necessitates judicial training that is ongoing and recurring to both teach initial skills and also to help judges refine those skills to ensure they are being applied effectively in the courtroom. This training should be developed to be judge-specific, but also to be in collaboration with community partners and an advisory committee formed by the Chief Justice. Currently, there is a 1-hour session during the new judge training seminar related to domestic and sexual violence, and OJD recently had 2 1-hour sessions on the dynamics of domestic violence at its most recent judicial conference. In addition, the State Family Law Advisory Committee has developed FAPA and ERPO bench books and bench cards for judicial use, but those materials don't necessarily address the courtroom dynamics judges must understand and manage in cases involving domestic and sexual violence. Judges are in need of additional, more specialized professional training on domestic and sexual violence, and in particular, skill-based and evidence-based training to include training related to understanding trauma responses and also how to manage those dynamics in a courtroom. This level of training will improve the experience of litigants and others who come into our courtrooms, provide better access to justice, improve our ability to make accurate credibility determinations, improve outcomes, and quite simply help judges do our incredibly important job better. Mandated training will help promote accountability to our independently elected judicial officers. This level of training requirement will also need to be adequately funded so that we can truly provide professional and effective training to our judges. Judges need to have practical, ongoing education and training that is geared toward what we do every day and not the current CLE requirements that don't provide training focused on judicial educational needs. I hereby provide my support for SB 710 and its concept of providing mandated specialized education to judges in the important area of domestic and sexual violence. I'm happy to answer any questions, and I thank you for your time, Chair Krupp, Vice Chairs Choatson and Wallen, and members of the committee.
Judge, thank you so much. Is there any questions? Representative Anderson.
Yeah, thank you, Chair Croft, and thank you very much, Judge. I am a lawyer. Not all people on this committee are lawyers, but I understand the CLE requirements. My question is, will this be an addition to the 45 hours you have to get every 3 years, or will it be included inside the 45 hours?
You know, I'm guessing at the initial phase that this would be in addition, but I don't know what the end result of both this bill, SB 710, and other bills that are out there involving judicial training. I don't know where that might go, but I do realize that for now it's likely to be in addition to the current CLE requirements.
Follow up?
Yes, please.
Thank you. Yeah, I scanned the bill, didn't peruse it. I didn't see any answer to that. And I guess you could say I'm asking for a friend who happens to be my daughter-in-law, who is a circuit court judge. So I think probably the Chief Justice will have a little authority to decide whether it's on top of or included underneath the 45 hours.
Yeah, and I put that part in there because I do think personally, in my experience, having really specialized training for judges is what I would like to see happen. You know, we have a limited amount of time that we can spend in trainings every year, and I want to get the best training that I possibly can. And sometimes the CLE requirements don't seem to fit exactly what I think we need.
Thank you.
Right. Representative Mannix.
Thank you, Mr. Chairman. Having read the bill, my interpretation is the Chief Justice can set up separate training, but there's nothing in this bill that would prevent the Chief Justice from applying to the bar for those credit hours to be treated as appropriate mandatory continuing legal education in addition to being judicial education, because having just completed my 45-hour requirement, I'm sensitive to the amount of time you have to put in on. But my perception is it can be done, it just can be done administratively from what I read in this bill, and I'll be corrected if I'm wrong.
Yeah, I would agree too.
We're going to hear from Aaron later, and I'm sure he can answer some of those questions.
Thank you.
Welcome. Judge, thank you so much for being with us today.
Thank you for having me again.
And so I think we have 4 people from the Family Justice Center. Do you want to come up maybe 2 at a time? Rachel and Jen, do you want to start us off? And then Lisa and Yvette come up after them. Go ahead.
Thank you. Members of the House Judiciary Committee, thank you for having us today. I really appreciate it. My name is Rachel Schutz, and I'm the Executive Director of the Family Justice Center of Washington County. And those here with me today are members of our Voices Committee, who are survivors that are choosing to use their experience and voices to advocate on behalf of survivors, not only in our community, but in communities across Oregon. So I'm here in strong support of Senate Bill 710 because our court system must be equipped to understand and respond to domestic and sexual violence. After nearly 20 years in social services, I thought I understood family violence, but it wasn't until I came to the Family Justice Center where I saw the deep, insidious complexities of violence and abuse. This knowledge was not common, and it's not standard training for our judges. This gap has real consequences. Every day, survivors and their children walk into court hoping for safety and justice. But too often, the courts don't fully understand the depth of trauma, coercive control, and the dangers that they face. When abuse isn't understood, decisions can unintentionally put children and survivors at risk. Not because judges don't care, but because they haven't been given the tools to recognize the full picture. Oregon has some of the highest rates of domestic and sexual violence in the country. This means that trauma-informed judicial education isn't a luxury, it's a necessity. Senate Bill 710 ensures judges receive evidence-based training on the dynamics of abuse, lethality risk factors, and the impacts that this can have on children. This bill is more than education. It is about ensuring survivors are heard, understood, and protected, and for survivors, that is access to justice. Thank you very much for hearing us today.
Thank you for being here. Jen?
Thank you. Thank you for allowing me to speak today. My name is Jen Bartholomew, and I am a member of the Voices Survivor Advisory Committee. I am intelligent, empathetic, and a great mom. I am also a survivor of 25 years of psychological, emotional, financial, and sexual abuse. I was on the verge of suicide and desperate to protect my kids from their father when I finally found the courage to file for divorce. Every time I'd sought help from police, DHS, mediators, circuit court, conciliation services, I was never directed to a single resource. I felt alone, scared, and deserted by systems that I thought would help. The need for training and understanding of domestic violence and sexual abuse within our legal system is urgent. Without this training, judges go blindly into serious situations, particularly for children who are most vulnerable. When signs of trauma and abuse are missed or ignored, judges' rulings can subject victims to further abuse. This happened with me and my children. Abuse knows no age or gender and extends far beyond physical violence. Coercive control is a significant form of abuse. I was verbally assaulted, threatened, humiliated, blamed, and gaslit my entire marriage. Abusers prioritize winning over justice and look for every loophole in the law. It's the judge's responsibility to arm themselves with the ability to see through deception, especially when a survivor doesn't have an attorney and an abuser does. I am part of that 86%. My abuser created a false narrative to his attorney, and I couldn't afford one, so I was unrepresented. This should have been a huge red flag to my judge. Despite my many attempts to share the truth with proof, his attorney didn't care what I had to say. Judges need to understand that attorneys do not care if their client is an abuser. They care about their client winning. The adversarial nature of our system dismisses real human suffering, and it inadvertently protects abusers. The expectation in court is to be quiet and unemotional, and my abuser's attorney didn't tell the truth, so my kids and my voices were silent. My judge didn't know what happened in the home before I filed, how the previous 8 months had gone since I was served with his modifications, nor what I knew what was to come because of his proposed plans. It was and still is a living hell because no one listened. Survivors endure extra challenges the moment they file anything, and those challenges continue well past court dates. Abuse does not end when a divorce or a judgment occurs. Abusers don't want to lose control, and they will do everything possible to keep it. Judges must be trauma-informed and educated on the dynamics of abuse that survivors face. Ongoing training that emphasizes the nuances of domestic abuse can't be optional. These are real lives that are being further destroyed by a system that should be protecting them. I urge you to support initiatives like Bill 710, Senate Bill 710, that enhances the judge's ability to recognize and respond to domestic and sexual abuse and violence. Training and awareness are essential for a judicial environment that validates victims' experiences and restores faith in the system. It's up to judges to make final rulings that keep people safe, and this training will literally save lives.
Rachel and Jen, thank you for being here. I appreciate it.
Thank you. If you have any questions after everybody's spoken, I'm happy to answer anything you guys might want.
Why don't we take Lisa and Yvette, and we'll see if there's questions. If you want to, Rachel, if you want to stay, and because we have three, sorry, it's just only,
Not a
I would have called
problem.
all four of you up there, but we only have three chairs. Welcome.
Hi. Good afternoon, chairs and members of the committee. My name is Lisa Jones, and I am here as a survivor of domestic violence, a mother, and a passionate advocate for change. I serve on the Voices Survivor Committee of the Family Justice Center of Washington County, where I work alongside other survivors to improve support systems and promote policies that protect those affected by domestic violence and sexual assault and child abuse. I'm honored to be here today with my oldest son, Finn. He is part of my story and a big part of why I'm here today advocating for change. I'm here to urge you to pass Senate Bill 710, which will require mandatory domestic violence and sexual assault education for all judges and court staff. My experience in the family court was not protective, it was harmful. I was treated as a perpetrator while my abuser faced no accountability. I was involved in a CPS case, and the court's lack of trauma and abuse-informed understanding led to devastating outcomes for me and my children. After my mother, my strongest supporter, and my designated safety service provider passed away, my children were suddenly removed based on uninvestigated assumptions and not facts. They were placed in a system that overlooked the real trauma we had endured. My youngest son at the time was placed in foster care for months. When he returned, he was no longer the joyful child I knew. He was later diagnosed with complex PTSD, a direct result of the court's decisions. Too often, survivors are met with skepticism instead of support. In my experience, without proper education, courts rely on outdated myths, personal biases, and incomplete CPS reports, rather than truly understanding abuse and trauma. With this training, judges and court staff could better recognize the nuances of trauma, the power dynamics in abusive relationships, and the ways the system itself re-traumatizes survivors. They could make informed, just decisions that prioritize safety and healing rather than perpetuating harm. At the core of this issue is a simple truth. We need to believe survivors. When we don't, injustice continues and survivors are re-traumatized. Believing survivors means making informed decisions based on facts and not assumptions. Survivors deserve to be seen, heard, and protective. You have the power to change that. Please support Senate Bill 710 for survivors like me and for children like my son Finn who are watching and counting on you. Thank you for your time today.
Thank you.
Thank you for having me here, House Judiciary. I really appreciate it. I'm a little nervous. This is my first time. My name is Yvette. I am a survivor of domestic violence, and I'm a protective parent who lost custody in August of 2023. Not because I posed a risk to my child, but because I sought help for the trauma and abuse that we have endured. I am also the 86% of litigants who have gone in without an attorney. On the first day of my trial in that year, I was jailed for asking for an attorney because I did not have the capacity to represent myself. When I left my abuser with my infant son, I did everything right. I sought support, I relocated safely, and I provided consistent care. Yet in court, my mental health became the focus, not the abuse. An evaluator with no specialized training in DV made a recommendation that ultimately cost me custody despite no prior concerns about my parenting. In Oregon, custody evaluators and parenting coordinators are not required to be licensed or certified in domestic violence, coercive control, or trauma. Their assessments carry great weight in court, yet there's no oversight or regulation to ensure they're qualified to handle these complex cases. That's why Senate Bill 710 is critical. By requiring all judges to be trained in domestic violence and sexual assault, we empower them to recognize trauma-informed behaviors, question flawed evaluations, and mitigate harm caused by professionals who lack the expertise or accountability. Judges are often the last line of defense for families like mine. With proper DVSA training, they can ensure court decisions are grounded in safety, context, and justice, not bias and misinformation. Please support SB 710. Survivors and our children are counting on you. When you guys make a vote for this bill, please know that your decisions are just as impactful as those of the judges who are overseeing our cases and making decisions for our children and our families.
Thank you for being here. Members, any questions? I just want to say thank you for championing this bill and the work that you do. I spent a large chunk of my career in the criminal justice system, and I spent a large chunk of my career probably not really understanding what I was seeing in the courtroom, and that wasn't for a lack of good intentions, but just from a lack of training and experience to appreciate the sort of background that led people to being in our courtrooms. And so this is important work to continue to push forward. So thank you for your efforts.
Thank you. I appreciate you saying that too. And just to sort of highlight that, I've met many people in my career, and having been in social services and casework specifically, until I was in this work fully and had to go through specialized training, I did not understand. And I made decisions that were well-intentioned, but I did not fully understand, simply because this, for whatever reason, is still not common knowledge. And so this is just an effort to make it part of the common education of people in justice and social service avenues. So thank you.
Yeah, I spent a lot of my career going to trainings on how to do like opening statements and closing statements. And I feel like the training I went to about how trauma impacts people was the most insightful, impactful training that I went to, and actually provided a greater level of clarity to what I was working on in the court system.
Yeah, absolutely.
Thank you for being here.
Thank you very much.
Aaron, you want to come up?
And good afternoon, Chair Kropp, members of the committee. For the record, my name is Aaron Knott. I am the Director of Governmental Relations and Communications at the Oregon Judicial Department, here in support of Senate Bill 710. You've heard from previous panelists about the profound impacts that trauma can have on one's experience in the courtroom. The manifestations of trauma can affect memory, they can affect testimony, but more than that, court is itself often a traumatizing experience and can be deeply re-traumatizing for people who have to tell difficult stories over and over again. And so this was an easy bill for us to come forward and support in that sense. I think the challenge with this bill wasn't whether we would support it, but how we would make it work. And I want to take a moment and thank Senators Salman, Weber, the other proponents, and the previous panelists for working with OJD to figure out how to tackle this question of how do you train judges? You heard from presiding Judge Guptill that judges are actually a lot like the lawyers up in this committee in the sense of what they're asked to complete to be attorneys. They receive CLE credits, they turn them in with the bar, and there's actually not an extensive existing mechanism for the Chief Justice to say, this is a training you should get, not as an attorney, but as a judge. And there are subject matters, and this is one, where when you are presiding over the courtroom, the techniques that are necessary to help a person who is experiencing trauma navigate the court system has to start with the judge. That has to be a judge-specific training. So again, we want to thank the sponsors for allowing us to build that structure. And to answer a good question, Representative Anderson, I get your point. We don't want this to just be one more thing that judges need to do in an already busy schedule. It's important, but we need to find ways to make it easy for them. So CLE credit is one part of that, and that is something we will request. I expect they'll get general credit within the 45 hours, just like Representative Mannix and Representative Anderson suggested. But we'll also investigate how to deliver this training in ways that works for them, digital options, remote options, other options, that they can work into an already busy docket schedule while giving this critical issue the attention it deserves. So with that, proud to support the bill and happy to answer any questions.
Great, members, Representative Manning?
Quick question. Have we had a chance to see if there's such programs around the country where we might be able to have generic training that applies to the subject that we might be able to assimilate?
So, Chair Kropp, Representative Mannix, thank you for that question. One feature of this bill I actually wish I'd mentioned already is that it does contemplate a real community focused and community engaged process where there will be an advisory committee that is formed to put this together, which will give us the opportunity to make that kind of an investigation and root it in community providers, not just judges.
Thank you.
Vice Chair?
Thank you, Chair. Thank you to everyone who testified on this and all the work that went into it. Just a technical question. Do you anticipate that all the trainings would be subject to public records requests? I would think so, but I'm just curious if that's been thought about.
Like what the training is or whether somebody did the training?
No, the content of the training itself. I think that there's a public interest in how we're teaching and informing our judges. And I mean, I don't have any specific angle here other than just I think that's something, in the same way of community input in creating it, that people would want to know what training the judge had received and what the content of that training is.
Chair Kropp, Representative Choten, that is an excellent curveball question. I don't know. My gut reaction, which I should never share publicly, is the same as yours, is that it probably would be open to public record, but I will follow up on that and give you a written response.
Thank you.
Representative Lewis?
Thank you, Chair. Is there an annual judicial conference?
Chair Kropp, Representative Lewis, yes, there is. And there are limited windows for training available there, but it tends to be busy.
Aaron, thank you.
Thank you.
Thank you, everybody that was here today. With that, I will close the public hearing on Senate Bill 710A.